Bill called me today. Remember I told you to call? Well,
Come up here.
okay, I'll come up.
It's your mug on TV. Hurry up.
You want to go, Counselor, did you want to go into the issue of no notary on the
A
complaint?
friend of ours today was in a hearing.
Step up to the microphone.
Sorry, all right.
Up to the mic.
Hello?
Are you afraid of that mic?
No, I'm not.
Hug it.
Today, a friend of ours was in court today, and it was a civil matter over a medical bill. And he went in, and he had filed an affidavit. Please. And he went in, and he never approached the bench. He stood behind the bar. And the judge asked him who he was, and he said, "I'm the secured party." Judge says, "Okay." He said, "Are you here on this matter?" He said, "Yes, I am. I'm here on this matter, and I'd like to know who has a claim against me." He asked the judge, he said, "Judge, you have a claim against me?" And the judge said, "No, I have no claim against you." And he asked the attorney, and the attorney responded the same way. And then the judge attempted to say, "Well, what's your name?" He says, "Well, I'm the secured party." And this went on for about an hour. Okay. And so the judge continued to try to say, "Are you Bill Galkowski?" He says, "No, I'm the secured party." And he again asked, "Do you have a claim against me, Judge?" Judge says, "No." And this went back and forth. And the judge, this is what he said to me. He said, the judge said at a certain point, he said, "You know, this is over a medical bill." He says, "You know, the doctors did work on you, and they kind of want to get paid." He said, "Well, do you have a claim against me?" Judge says, "No." He says, "Are you rebutting my affidavit?" Judge said, "No." He says, "Then what are we doing here?" And this went on and on. So the judge took a recess, and they came back an hour later, and they started court. And see, that wasn't even court. That was just getting to, are they going to have a hearing today? Because the judge didn't know what to do. So they he has court, the court opens, and back to the same old thing. Are you rebutting my affidavit? Judge said no. Every time the judge made a statement, Bill said, "Are you rebutting my affidavit?" And the judge started getting a little bit perturbed, and he apologized to the judge, and he asked the attorney, "Do you have a claim against me?" And the attorney said no. And the judge just stepped right in, and he says, "Well, it's so-and-so medical company that has a claim." And Bill said, "Okay, well, I'd like to bring them to the stand." The judge says, "We're not going to have any of that." And so what ended up happening is that the judge, being that the defendant never appeared, he said, "Are you representing the defendant?" That's what the judge ended up saying, because Bill never made his appearance. He never admitted to being that person. He was just a secured party. And the defendant, or the plaintiff, moved for a default judgment for failure to appear at the hearing. And that's what happened. And that's what will happen. So that's what happened to Bill today.
Okay.
So he never appeared because he never mentioned his name. He never addressed the address. He said he received mail at a location, but he never admitted and never deviated from the path that he took, and that was to stay on his affidavit and stay on point. The judge continued to try to get him off point and to traverse, and Bill just demurred and asked questions. So that was a story from New Jersey today.
Okay.
All right?
Why would anybody even appear if that's what they're going to do? Why even appear?
The question is, why even appear if that's what you're going to do? Well, I talked to Bill for the last 2 weeks off and on, and I said, I wouldn't do this. Okay? This is his method and his way of doing it from the 19 different people that he talks to. Okay? See, to me, you're creating an element of controversy, especially in that civil setting, that doesn't need to be there. Because they don't have a claim, they got an empty deal there. But it is an issue in controversy, and number one, he had an affidavit, and number two, if he would have accepted it for value, he said, I don't understand the controversy under public policy, somebody's got to adjust my account, what's the remedy? I have no money. Okay? He don't want to go that route, he wants to do this other thing with, as, quote, the secured party. Well, who's the secured party? Identify yourself. Where's your claim? I don't know if he put his claim forward.
Well, Sam, if you take that same context that you just had, and the judge asked, who are you? And then he was saying, well, he's, what was the term that he used?
The secured party.
He was a secured party. What he would have to have said, to just clear it up, is I'm one of the parties in interest.
Okay?
Why? Because he turned in the affidavit. He turned in his UCC-1. And there is only one secured party and interest on that form. Just one.
Actually, he's a third-party intervener. You could state that.
I don't want to go there.
Well, yeah, but what it says is secured party. It says secured party. And there's only two people that are allowed on the courtroom floor at a time. Just two. The plaintiff and the defendant. And they have to be real parties in interest. At that point, when this guy opens his mouth, the first thing that I would have said is, excuse me, who are you?
Exactly.
And the judge is going to say, hold it. This is my courtroom, I'll ask the questions here. Who are you? And I'm saying, I'm the secured party in interest. This guy opens his mouth, and you stop him. You say, identify yourself, please. When he does that, and if the judge is getting hot, he's going to come roaring over the bench anytime, and you ask this man at that point, so you're representing these people, correct? Do you have a power of attorney to be here, sir? No power of attorney? Why?
Are you talking to the attorney that's the plaintiff's attorney? Oh,
Yes.
yes, absolutely, I have a power of attorney.
Would you mind if I seen that, please?
I don't have it with me.
Could you present that to the court in any shape or fashion?
Not right now.
Is there anything in the record that would reflect that there is a power of attorney on file in this court?
Court has nothing here.
Then I would request that this man remain silent.
Do you-
Either that, or
do you-
please bring the plaintiff forward to at least cite the charges against.
Is
Your
that
Honor, I
is that a
object.
motion?
This is,
I would make that as being a formal request.
Your Honor, I object.
Do you have a-
Excuse me, sir, until you
And
come
the
up with
grounds
a
for
power of
your
attorney, I have to
objection,
insist.
Counselor.
that
Just a
he-
moment, just a minute. He's responded to your accusation.
I object.
And the grounds for your objection?
Well, I have the
Under
power of
what
attorney.
what circumstances can he
Just-
possibly enter the
Counselor,
court without having some sort of a power of attorney?
You're out of order.
I'm just
I've
trying
asked
to
this
establish the
man
real
to
parties
state
in
the-
interest.
Counselor, I've asked him to state the reason for his objection. May he answer?
No, he's
Well,
not a
the
party in
court
interest
finds
here.
that he's allowed to answer and has asked you to remain mute until he does.
Fine.
Your Honor, I would object. I certainly do have power of attorney in this matter. I just don't have it with me in the file. And I can furnish that to the court shortly.
And how soon is shortly?
How long are we going to be here?
Well, we
I can get that back to the clerk
how
tomorrow.
long? Tomorrow. Well,
Yeah.
then,
Excuse me, Your Honor, that's not expedient at all. That will not do. I insist that he either have that in a short recess within 10 minutes, or I request that you release the order of the
now,
court to
you
me.
brought this matter to the court.
I understand, Your Honor. I sincerely apologize
It's
for
not to
delaying
defend-
this
And
time.
you don't have the authority with you,
Excuse me,
Counselor?
if he doesn't have any standing in this court, I insist that he remains silent.
Well, I'm trying to determine if he has standing in the
Well, all
court.
he has to do is come up with power of attorney, Your Honor, and I'll be happy to step down.
His point's well taken, Counselor. You should be prepared.
I understand, Your Honor. I
Your Honor,
apologize.
do you have my paperwork that I've given you, the specific negative averment and my acceptance for value?
Your Honor, I object. Those
Excuse
documents-
me, sir, until you have your power of attorney, remain silent. Shut
Your
up.
Honor, please.
I have the floor here, he has no standing.
Excuse me, I have an affidavit here from this
Thank
party,
you.
so-and-so.
Then-
Are you so-and-so?
I am the secured party in this matter.
Are you the person that prepared the affidavit?
I am indeed, sir, yes. Predicated upon my agreement or the acceptance for value, I would move that the motion, that the order of the court be released to me immediately, sir.
Your Honor, once again,
Excuse me,
There
we've
being
already
an
covered that. Would you mind
Counselor,
asking him
there
to
being
please
an
not
incomplete-
interrupt me?
There being an incomplete record substantiating the complaint, this court has no option but to dismiss.
Your
Unless you
Honor,
can come
I'm going to
forward.
lodge my strenuous objection.
Well, your objection's overruled.
I understand, Your Honor.